How is it like studying law in Peking University? A lot of you may not know yet that I am doing my law masters here in Peking University, a master's entitled Chinese Civil and Commercial Law. And I thought I'd jump into one facet of how it's like to study law at Peking University. I say one facet because honestly it's a very long story that I'll probably make multiple videos to express. But let me focus on the one facet today, that is the codified civil code method of Chinese law versus the UK uncodified common law system. It may sound like a very classic argument, but let me go into the nuances of the Chinese civil code that was introduced in 2021, consolidating a lot of sources into one final code. So, those of you who don't know, the UK system is rooted in common law, which means that case law plays a huge role in shaping the law. It operates by a precedent system where higher courts' decisions bind lower courts, and legal principles evolve over time through judicial interpretation. So, as a law student in the UK, for example, I may have to read Donahue and Stevenson to understand the basics of tort or negligence, or read Carlyle and Carbolic Smokeballs to understand the basics of contract law, because these two cases have greatly shaped legal doctrines, or at least have been the starting point for a lot of future cases to be built on these cases. And I have to analyze how future cases involve judges applying principles to the facts of these older cases, creating a dynamic, ever-changing system. But let's talk about China in contrast. China's legal system is based on civil law, which relies heavily on codified statutes rather than judicial decisions. Yes, this is a bit of a simplistic explanation, but it works for our purposes now. So the Chinese Civil Code in 2021 has various key sections. For example, there is a tort section and there is a contract section. Indeed, the codification of rules like legal systems like China can create some interesting debates as well, such as why are certain headers in the code. For example, as a side point, there's a very interesting debate on why personal rights are part of the Chinese Civil Code. Why did we carve out a specific header for it? This is not exclusively a Chinese phenomenon. The Chinese Civil Code is based off European civil codes, especially German ones, and based off Japanese legal codes as well. And these jurisdictions depend more heavily on their written codes as opposed to the precedents and i.e. case law as the common law systems do. So, what does this mean for me as a law student? For me, I wanted to know how lawyers in civil law systems think. One bias that we may have as common law lawyers is that we end up doing more of the thinking and grinding because of the innovativeness of needing to apply past cases to future cases by analogy. But this is a clear misconception, as I still see that even in a civil code system where things are written out clearly, there is still room for explanation and argument over the words. After all, law is communicated through language, which is always has a level of semantic unpredictability. For example, there are what we call Supreme People's Court judicial interpretations in China, which is a very interesting thing to learn because we can see how judges, through these interpretations, which are like formally written documents, actually expand on the code, the wordings of the code themselves. So, in that level, we sort of see a similar common law judicial involvement in interpreting the codes of the Chinese Civil Code. But at the same time, it's also something that's a totally different system. We see a bit more cooperation, perhaps, as opposed to stretching of the statutory words because of the different constitutional dynamics in China, where judicial interpretation should not override the legislative intent of the dominant legislature. One thing I also want to talk about is the very specifically Chinese concepts that I think are part of the civil code that I've never encountered in my study of English law. One of them is the part of the civil code that address rural collectives and land use. Let's break it down. So, for example, Article 55 defines rural land contractual management households as this: families or groups entrusted with operating rural land. It's a system designed to ensure land is managed efficiently while holding those involved accountable for its use. And then there is Article 56 as well, which outlines the financial responsibilities tied to this operation. It ensures that debts incurred by such households are clearly defined and enforceable. This provides a structured approach to balancing rights and responsibilities in rural areas. Why I say this is very much a Chinese characteristic is because of the dominant agricultural society that largely still permeates China. Many people are still operating in this rural land owned business, and thus the law, as it should, facilitates these kinds of collectives by allowing them to participate in contract making and therefore participate in the economy. So, studying law in China definitely has been interesting. Many people do ask me, can you practice there? And honestly, the unless I'm working as a consultant or as by a foreign lawyer, probably not. But why I still think this is interesting is because it gives me that intellectual fascination of understanding how historical and societal factors shape a very different legal system from what I'm used to. Growing up in Malaysia, I'm very much used to the common law system because Malaysia largely follows after the UK. Thus, learning both the civil code system, which is dominant in the European continental systems, and Japan and China and some other East Asian countries as well, and also Chinese law specifically, which has all these special characteristics like the rural collectives, has definitely showed me how social and historical factors shaped the law. I hope you enjoyed this video. Don't forget to like, subscribe, and share if you found this video helpful. See you next time.